Hi! In the second clip, I'd like to talk some more about the specific characteristics of the International Criminal Court. As you have understood by now, the ICC is not your regular domestic criminal court. Its jurisdiction is circumscribed, but the cases are very complex and the procedures therefore potentially very lengthy. There are also a number of specific characteristics that we need to understand if we really want to get behind the operation of the ICC, and those are the ones that I'd like to tackle in this clip, starting with the principle of individual responsibility, then the principle of complementarity, and finally talking about how the jurisdiction of the ICC gets triggered. I'd like to start with the most basic one, which you've probably also understood by now, and this is the principle of individual responsibility. If you look back at the previous weeks in this course and our discussions on international law so far, you can see how special the idea of individual responsibility really is. In principle, international law governs the relations between states. They are the primary subjects and they are the ones who are, in principle again, obliged by international legal norms. However, in the case of the International Criminal Court, individuals are held responsible for international crimes, for heinous acts, the crimes that I will be discussing in the third clip. And of course, how could it be any different? This is a criminal court and criminal proceedings can only be brought against individuals, not against other entities. States cannot be put on trial, they cannot be put in prison once they are convicted of certain acts. So this really is about individuals at the end of the day. A second aspect related to individual responsibility is that not every person that has allegedly committed the crimes in question is supposed to end up at the ICC, and this brings us already very close to the second principle, the principle of complementarity. The idea in international criminal law in general, but the ICC is no exception in this regard, is to bring in the big fish, those who ordered, planned, who were at the helm of the actions that were then executed by many others, by thousands of soldiers in the field. If you think about it, there are very sensible, practical reasons behind this notion. The ICC simply does not have the capacity, institutional or otherwise, to deal with the hundreds, perhaps thousands of cases of persons who throughout the world face allegations such as war crimes or crimes against humanity. The ICC cannot substitute domestic courts, which therefore actually have a very important role in the legal framework that the Rome Statute creates. And this precisely is the notion behind the complementarity principle. It is really hard to overstate its importance. It's one of the key ideas behind the creation of the ICC, namely that the ICC will only step in a complementary fashion, meaning that only in those specific cases where a state and specifically its domestic courts are either unwilling or unable to genuinely carry out their investigations and prosecute the persons who have allegedly committed these international crimes. Note that this is different, for example, from the International Criminal Tribunal for the former Yugoslavia, the ICTY, which had primacy over domestic courts, meaning that it could basically pick and choose the accused and take them in and prosecute them in case it thought that this was necessary. In the case of the ICC, this is not a possibility. The prosecution as well as the pretrial chamber have to check whether in fact the complementarity principle is met or whether domestic courts are actually effectively in a position to deliver justice in this specific case. This effectively creates a stage in the proceedings that precedes the actual criminal proceedings. And this, of course, is another specificity of the International Criminal Court. These pre-trial chamber proceedings can be also very lengthy and contribute further to the complexity and duration of ICC cases. Another vital aspect relates to when the jurisdiction of the ICC is actually triggered. And there are three possibilities here according to Article 13 of the Rome Statute. The first one being that a state refers a situation to the ICC. This of course includes state parties that have ratified the Rome Statute, but also potentially non-state parties which on an ad hoc basis can basically accept in a more circumscribed manner the jurisdiction of the ICC. And the most famous example here is Ukraine, which signed but did not ratify the Rome Statute, but has, however, through two declarations accepted the jurisdiction of the ICC for everything that basically happened since the invasion of Crimea in 2014 up until today. So actually the Russian invasion of Ukraine is within the purview of the ICC. The second mode of triggering the jurisdiction of the ICC is through a referral by the UN Security Council under Chapter 7. And as we know by now, the Security Council has far-reaching powers under Chapter 7, including to pass legally binding resolutions. So it does not come as a surprise that it is indeed a possibility for the Security Council to, so to say, forward a situation to the ICC if it deems that this is conducive to maintaining, re-establishing international peace and security. Of course, the usual caveats apply here in the sense that the Security Council is often deadlocked and there is likely to be disagreement on whether a situation should be referred to the ICC. However, it has happened in the past, most notably in 2008, when the Darfur situation was referred to the ICC, leading eventually to the indictment of Sudanese President Omar al-Bashir. Finally then, and this is another specific characteristic of the ICC, they're the Proprio motu powers of the prosecutor. What does that mean? Well, once a state has ratified the Rome Statute, it is actually within the authority of the prosecution of the Chief Prosecutor to launch proceedings out of their own motion. So to begin an investigation into a situation, even if the state party in question has not actually referred to the specific case. The start of an investigation does not necessarily mean that there will be a criminal case down the road. Of course, the principle of complementarity needs to be met, so perhaps there is already a domestic court that is pursuing this case in an effective way. And also the ICC prosecution could eventually conclude that there is not enough evidence to indict a specific individual. What's important to remember here, however, is that the prosecutor has this power to launch a case out of their own motion, which is what this Latin phrase proprio motu means. I'd like to end this video by mentioning the two persons who in recent years have held this important position of the ICC Chief Prosecutor. So here on the left side you see British lawyer Karim Khan, who took office in June 2021, replacing Fatou Bensouda from the Gambia, who had been the Chief Prosecutor from 2012. And of course this is a very high profile position, very political as well, because it is this person who at the end of the day makes the decision on whether an investigation should be launched and whether a case should actually effectively be opened. This concludes this second video. I'll now move on to discuss subject matter jurisdiction, namely specifically the 4 core international crimes that are covered by the ICC.